All right, good evening, everyone. My name is Randy Shannon. I'm here in Miami, Florida, and this is Tuesday, February 24th at 8 o'clock. And tonight we're having a special program because we have a guest that has won his lawsuit, and he's got some information that he wants to get out to everybody. And we know that when somebody wins against these guys, that this is something that needs to be shared fast, far, and wide. Not only for, their protection, but for ours as well. It's information that we all need. So I'm not going to talk very long. What I want to do is introduce Rodney Rouzan and have him give just a little bit of background, whatever he is willing to say, whatever he wants to share, and then talk about his case. And then I want some of the traffic remedies that were mentioned in the past. Whatever you can go into, Rodney, the floor is yours.
Okay, well, thank you, Randy. I appreciate it. And to give you guys a little bit of background about myself, originally straight out of high school, I went into the United States here. I'm getting a little bit of feedback here.
Okay. As I hear it, I'm blocking lines. So go ahead.
Okay. I entered into the United States Air Force directly out of the high school. And my tours pretty much led me right back to the Los Angeles area. But then the one deployment that I did do was I was deployed over to Kuwait. And when I got over to Kuwait, this was back in the year 2000, that I had got over to Kuwait. And then what I just recognized was, the devastation that we had caused to over there in the country. I just saw there was a point, in Kuwait, where I saw everything was blown up, and we called it the boneyard. And you just saw devastation as far as the eye could see. So I guess as you come along, that's some of your awakening what's going on. I'm a 19-year-old kid at the time, and I'm looking at what's going on, and I'm just like, this doesn't seem right for us to be over here, just destroying people, millions of people. So that little seed was planted fine. In approximately the year.
Go ahead.
Okay, are we ready? Okay.
Yes.
Okay, so then from after my endeavors in the Air Force, I exited out a couple of years. I exited out 6 months early, and I entered into the law enforcement. My older brother was in law enforcement, and he had encouraged me to join. And I was one of the youngest officers ever hired. Went to the police academy at 20 years old, and in the Los Angeles area. Since that point in time, I've been serving in patrol for the last 15 years. As I got into the police force, it took me, I think 2011 was the first time I realized that I had an oath of office. Now, as I went back and looked at my records, I realized you do take the oath. I actually have pictures of myself taking the oath at graduation day, but there really was no significance behind it. I don't think any officer, they may know it now, but in the past, in 2011, I almost questioned almost the entire department, and not one officer knew what that oath said. So I found it very strange. And then I actually found out that we had a federal constitution and a state constitution. This was completely foreign to me. And one reason why I found it strange is foreign to me because my father was in law enforcement. Like I said, I have two brothers in law enforcement. Brother-in-law is in law enforcement, and my uncle was the chief of police of Inglewood. So, and Inglewood, California is a little suburban location right down here next to Los Angeles. So I just found it very odd, and then as I'm looking into what's going on, I'm finding that the Constitution and the statutes and codes seem not to be in harmony with each other. So I just started asking questions and started doing reading, and I realized it put me at the front. I got a lot of complaints from sergeants about me talking about the Constitution and why are we violating it. And at one point in time, I am on the board of directors for the officers. So what the board of directors is, it's the officers union. I'm on the officers union. And by being one of the board of directors, I started as the treasurer, and then I've been also a board of director for approximately 10 years now. So when an officer has a shooting, whatever may happen, I'm the one that they call, and then we're there to represent the officer's rights. or protect the officers' rights until we can get the attorneys there. And what I found was that, just nobody knew any of this stuff. Nobody knew about the oath. And so what I did was I wrote an article entitled Oath of Office. And I laid it out there, what was in our oath and how we should be acting according to law. And it put me on the front of the radar. And very shortly thereafter that article was written, I came under fire from the Internal Affairs unit. And they opened up an Internal Affairs investigation for misconduct while I was off duty. And to give you a little bit of background, the incident while I was off duty, I also had owned a business. And when I owned that business, I found that my partner, it was a flooring and a furniture business, and I found that my partner that I was in business with was stealing from me. So once I found out that he was stealing from me, obviously I got into a lot of litigation but I found I didn't have good records. So when I didn't have those good records, pretty much at that point in time, I didn't have much legal remedy. So we went back and forth. He was my neighbor also, so he made some false allegations against me. And those allegations included one day where he was chasing my wife, chasing my kids around the neighborhood as they left our home. And then later on, him, along with two other individuals, come to my door just later on after my wife evaded them. And once they get to my front door, I order them to leave the door, which they comply. And then approximately 5 minutes later, two of the men come back. And when they come back to the front door, at this point in time, I call the local sheriff's department. And I tell them that I need assistance immediately. And I identify myself as an off-duty police officer. Sheriff's department notifies me on the phone, and they say, we're already en route for a man with a gun call. And I found that kind of strange, so immediately I'm waiting for the sheriff to show up, which they never show up. About 2 hours later, I call them, and I'm like, where are you guys at? Why are you not showing up? And they tell me that they already cleared the call, and they say it was no crime. Because little be known to me, these individuals, when they came to my front door, they had called the sheriff's department, and it was a setup and they told the sheriff's department that I had a gun, or that I had a gun inside my house. But however, the sheriff's department said, okay, we don't have a crime here, so at this point in time, we're just leaving. So with that being said, it was found that there was no crime. The sheriff's department took no crime report, and my department actually supported me for about the first month. And they said, we're not even going to take these reports from these guys. The guys are saying that you chased them down the street with a firearm. But they said this is ridiculous. The sheriff was on scene, so it doesn't even deem an investigation. Now, as I continue to talk about the oath for the next few months, I keep stressing the Constitution. The department comes back and decides to open up a full internal affairs investigation on me. And within that investigation, they eventually, a year later, find me guilty of all charges, and they terminate my employment. Totally no crime report. It's never been done in the history of the department. So at that point in time, I found myself without a job. This is all that I knew. I've been doing it for the last, at this point in time, the last 12 years. And I found a lot of, so originally I started off with the department's union attorneys. And when you start off with the union attorneys, I just found that they weren't making really valid arguments for me. And it just felt like it was a setup, and they were working with management. So at this point in time, I just decided, I said, you know what? The only one that can defend myself is myself, and I can do it the best. So I get rid of all the union attorneys, and I decided to handle the case on my own. I waive all my Peace Officer Bill of Rights and decide to have an open public hearing. And I actually went to a seminar and invited everybody that would come, and one day, I believe 100 people showed up. Now, the building was surrounded by the Los Angeles Police Department Metro Division, and I was actually also served restraining orders from the Chief of Police. They were doing everything they could to make sure I never returned back to work. Well, I went through 3 days of testimony. I cross-examined the Chief of Police and multiple of my captains and superiors, and nobody could explain the story. Nobody could explain how I didn't commit a crime, but how I could get terminated. So went through the process, and after hearing, the hearing officer decided to have me reinstated back to my employment with no loss of pay or wages. So I was reinstated like it never had happened. But one of the unique things that was said at the reinstatement hearing was that we don't want this man to return back to work because he believes in the Constitution. And they said, by him believing the Constitution, we believe him to be a sovereign citizen. And they said, the Constitution is in conflict with the statutes and codes, and we don't believe he can enforce it. So with that being said, the Civil Service Board, which is the board that I was able to appeal my termination, immediately said, you cannot argue his political issues, and we're going to reinstate him over your objections. He's stating this to the city attorney. So I go back to work, and at that point in time, I get back to work, and I'm just wondering how did I get fired for trying to uphold my oath and teach other officers the oath, and every single thing was fraud. Let me backtrack here. The day I got terminated, which was actually on, I think it was May 22nd, 2012, I get terminated from my job. Now what I find is the Internal Affairs Unit had notified my neighbors that I had been terminated. And that's one of the things that's against the law. Whenever you make a complaint to a police officer, you're never allowed to know what the punishment is. They just serve discipline. And it would be against the law for the Internal Affairs Unit to notify anybody that whatever the discipline was. Well, what happened was they actually had told my neighbor that they were getting ready to terminate me. And the day I got fired, I had walked down the street and had a little conversation with him. And I told him how I knew he was lying and how he had caused the damage in my life. And he had actually told me, he says, I already know you were terminated because they told me. And then later that day, he makes another false 911 call to the sheriff's department. And the sheriff's department comes out, and they actually come in. They have been notified by my department already, and they come in and they pull my whole family out at gunpoint, and they search our house for approximately 25 minutes. They were looking for a gun, and they couldn't find any guns. And actually, the whole confrontation with my neighbor had been videotaped, which was a good thing. And by the time the supervisor gets there, they find that no crime had occurred. So they brush me off. They send me and my family back into the house after embarrassing us, pulling us out at gunpoint. And that was just a really, I just started to really see how law enforcement can turn their back on somebody. You're part of the fraternity, but once you go against it, they turn their back on you. And they'll do whatever they can to get rid of you. So with that being said, subsequently, while I was also handling my case, I decided to go into the federal courts and open up a civil rights violation against these deputies and I did it under Title 42, Section 1983. And I went after them, and, federal litigation is a long process. And it was a lot of learning that I had to do, but once you read and you start to study, it becomes very easy. So that's just giving you a little bit of background on the termination, and then when the sheriff's department came into my house. So that gives you, this is where I'm starting to learn, and I start to read the rules on how to defend myself, how litigation works. I started doing tons of depositions. I probably deposed about 20 to 30 police officers. And it was really an interesting event because I knew everything that they were, I would know all the answers before they would even say it, because I find that we're all programmed the exact same way. Subsequently, while I'm still in the discovery process with the sheriffs in the federal court, I end up going back to work. And I get back to work, and one of the first things I do is I go back and I look for that oath of office. Because as I got back, I went to my personnel folder. I said, where is my oath? And subsequently, I find out it was not followed according to law. I sent out a request to the chief of police asking for where the oath was, and pretty much he told me, he said, go back to work and be quiet. Don't worry about it. So I started sending multiple notifications to him, and eventually he agreed to come swear me in. But by being the board of director, I demanded that he do an audit of our entire department, which consists of approximately the officers.
How many?
550.
Okay.
Okay. Now, that audit subsequently revealed that 390 officers had no oath of office. And I started to, I had got the union attorneys, and we got ready to do litigation against them. And we were going to do what they call a writ of mandamus to compel them to swear everybody in. But the city attorneys had threatened that if we did it, that they would try to seek cost. And I guess our union president got cold feet about it. So we never compelled the chief to swear everybody in. So the really disturbing part you'll find right now is I know of 390 officers today that are walking the street as we speak with no oath. And there's nothing I can do about it.
And nobody seems to care, and they blamed it on cost?
Well, not cost. He just doesn't want to do it. And I think it's just more or less embarrassment. And because he had asked me what would be the solution. I said the solution is to stand all these guys in the parking lot at one time and swear them in. But it seems as they're refusing to do that.
In your lawsuit, did it matter that no one had an oath?
Well, my lawsuit was not against. Originally, I had a lawsuit against the local sheriff's department who came into my house while I was at home. The oaths that are missing is for my department. At my department, they don't have an oath. Like I said, 390 officers don't have an oath. As far as I haven't sued my personal department. I sued the local sheriff's department for entering my home without a warrant. Without a warrant and without call.
Okay, thank you.
So, with that being said, so as I'm back to work, I'm discovering that we don't. I learned particular skills in court, and I took court to the street. And one of the things that I learned is court has rules and regulations, and there's a certain way to file various things. Now, one thing it says, and this goes back biblically, if you're reading the Bible, and one of the things it says is to give your brother notice. So, and you'll find this in your personal life. Oftentimes you may have an issue, and before something happens, an attorney will send you a notification letter before they decide to sue you. And in law, this is often called letters of Estoppel. So what I started to do, I took the format of a motion. And a motion, when you're in a court of law, the first thing that happens is there's a complaint that's filed. And when you file that complaint and you have a cause of action, and the cause of it, anytime you want, if I want to litigate against you, for example, Randy, what I was, and let's say I'll give you an example, defamation of character. Okay, so I would take something that you say, and then I would look up the causes of action for defamation of character, or it could be libel and slander, and I look it up and I make sure I have all those elements necessary, and that's what I have to plead, and that's what I have to have in my initial complaint. So the way the law works, as long as you have those initial elements present, you should make it to the next round. If those elements are not there and not present, and say you're claiming a cause of action for defamation, and all the elements aren't there, or you didn't plead all the elements, that's where the attorneys will come in and they'll do what they call a motion to dismiss. And so that's the first part of litigation. If you can get past the demur stage, or they call it the flurry of motions, then you're into discovery. And now once you're in discovery, they call it, it's like a game of go fish. There's 5 different levels, 5 different things that you can use to get what you need. One being subpoena, one being production. And production is, I can walk up to you and say, okay, I need this, this, and this. Like, so say you're dealing with the police department. I want your policy and procedure manual for this. I want this. So you can ask them for whatever you want. Another thing you may do, so that's production. The other one is interrogatories, where you can ask them questions, and then they have to answer it under oath. So there could be a lot of different, you can do a lot of different things with interrogatories. Another one is you get them to admit something on the record. For example, admit you walked into my house without a warrant. Okay, so they have to admit that. The next thing is subpoena power. So I can subpoena all your records. I can subpoena whatever I want. I can subpoena those oaths of offices. If you don't have an oath of office, therefore you're not a police officer by law. Okay? Mm-hmm. And then the final thing is, and this is where the rubber meets the road, is your deposition. And it takes a lot of skill, it takes time, and it takes practice. Because you're going to be dealing with a bar licensed attorney who is really skilled in law. And he's going to object to everything you do. Because his goal is to keep his client off the record. And so every single time if you ask a two-part question, objection, compound question, objection, relevance, objection, then lay a foundation. So you're getting hit with so many different objections where you have to learn how to operate within the system. Kind of how it works. To go back to my story a little bit, and then we'll go into that more in detail. I went through with the sheriff's department and sued them. The suit opened December 4th, 2012 is when I actually filed my initial complaint, and I made it past all the demur phases. And then subsequently, we got into discovery. I think I did about 20 depositions in that case alone. And then you get to what you call the summary judgment phase. I got past the summary judgment phase, and then I ended up with 2 causes of action because you're going to find the judges are really, they don't even rule according to law. But my case was so solid, they had no choice but to let me through. So I ended up with I ended up with 1 cause of action left. She knocked out 3. And the 1 cause of action I had left was the unlawful entry of my home without a warrant. Okay. And that cause of action, we were supposed to go to trial on January 13th, and we got to what they call a settlement conference. And we got to the settlement conference, and they were really filling me out, testing me. But when I saw the lady from the bank came with the attorney, they settled. And I think one of the things where they settled, because I threatened them, I says, and it wasn't a threat, it was a promise actually. I said, if you get those officers on the stand, I know they're lying, and I said, I'm going to get them on the Brady list. And the Brady list is what you can do to a police officer if he's lying under oath. If you catch him lying under oath and you can prove it, you put him on the Brady list, and then he no longer can testify again, so he's actually useless to the department. Mm-hmm. So at that point in time when I told them that, they came back and pretty much the offer that they started out with went up 10 times the amount that they originally started. And then they came back and settled the case. I believe it was November 12th. November 12th of 2014 is the day we entered a settlement. And it was really interesting. As I entered that settlement, 4 days later, my department came back and opened up 2 more internal affairs complaints against me for bogus off-duty incidents again. So, I'm back to LAX now. I set a huge record on the chief of police. Recently, I know it's online, and Randy, if you get it to everybody out there, there's an affidavit that I did, and it had 14 pages long, an affidavit of everything that's happened to me. And I actually, by keeping and protecting the record, I had over 1,100 pages of exhibits to show all the damage that they've caused me and what they've been doing, and it was facts and evidence. So,
everyone on the call has that. I sent that out.
Okay, and what you're missing is what I haven't released yet is the exhibits, because you're going to see it's going to say see attached, CD, and that's the one where you're actually 34 exhibits in the document, but those 34 exhibits were 1,100 pages, so I had to put them on a disk for obvious reasons. Okay. And that was just recently served on the entire. Like I said, I don't. Just for my protection, due to the fact I'm still at work, I can't state my department. You can see it in the affidavit; it's clearly there. Mm-hmm. But this was served on the entire city of Los Angeles, all the way to the mayor. I served it on about 54 people. And it was really interesting after I did that, the chief of police sends me a letter, and he tells me they don't want me contacting the city, they don't want me contacting anybody. And they're actually trying to restrict my right to represent myself.
Wow.
So
Okay.
or suffer punitive damages, which could lead up to termination. And so I found some very, very disturbing things happening. Just yesterday, one of the other guys, well, let's say it like this. Our Officers Association, we have a very good president, vice president, and they stood back and watched my case and they listened to what I said, so they really support what I've been saying. And we actually had just recently did a article that came out a couple of days ago because we had a whole raid that the department did. They didn't have any lawful authority to do it. They hit 25 houses at one time on search warrants and had no lawful authority to do it. Ended up with no convictions at all. And we came out to the news media to express this. And we did press conferences trying to get the story out to the public. And as a result, one of our other guys was just terminated yesterday. So it's just got to a really frustrating point for us. We have our board of directors. We're all minority officers, and actually all black males per se. And each and every one of us have an internal affairs complaint against us right now. And it looks like the chief may just go down the list and fire all of us and just make us fight for our jobs back.
Wow, they didn't lose enough on the first lawsuit? Or, well, I guess it really wasn't to them. Okay, go ahead.
Yeah, because what you're going to find is, and where their immunity is at, what happened in my situation is when you're terminated from the police department, the chief makes his decision, but there's a review civil service commission, which is at the city level. So you have all the departments, and then you have the city of Los Angeles where you can go to. And I was able to appeal it at that point. So when they put you back to work and then they give you full back pay, then they say that nothing happened. And then you don't even have remedy in law at the time because the chief operates with governmental immunity. So he pretty much can do that. You can lose all your pay for a year and then you get back pay. But you obviously know when that happens, everybody has bills, everybody's family has to eat. So when they terminate you from your employment and cut your payoff for a year, it can obviously cause some problems in your life. Yeah. So one thing that I learned on how to protect myself now is the record. So one thing that they were really upset about was when I served that affidavit on them, because that affidavit now pretty much is constructive notice on the chief of police and everybody in the city. So in the event that I were to get terminated and it'd be wrongful again, at that point in time, I'm holding all those officers in their personal capacity. And because I'm not even going after the city any longer. I'm going after their personal capacity because it's always somebody. When you're being damaged, yes, they may work for the city, but there's an agent. And you want to pull that person and that agent out of his capacity. He's like in a tank per se, and that's the way I look at it. But you want to pull him out of there where you can get to him. And when you can get to their pockets, that's the way to effectively, in my opinion, make change. So that's pretty much the story. That's some of my story right there, Randy. If you have any questions, then I can answer them. I can entertain them for a little bit here.
Okay.
Half an hour.
I'll let people ask some questions, but let me ask this. It had nothing to do with it. The hit on the 25 houses were what? No knock raids?
Okay. What you're going to find, the hit on the 25 houses was there was a big theft ring that was going on. There was a big giant theft ring that was going on, and they wanted to go after various employees that they felt were stealing, that were stealing various cargoes and things like that. So they had absolutely no crime reports. Okay. So they had no crime reports. So if you don't have a crime report, you don't have a victim. But it was one of those things where they just do it for the news media. So they hit all these houses. They have the news media with them. And then they find absolutely nothing. And wow. They arrest a few people when they break in everybody's house, and I call it a break-in. When they broke into everybody's houses, I think they ended up with 3 traffic warrants because people had just had traffic warrants. So that's the only arrest they really got out of it. And basically all those were kicked out. So they basically had nothing, and it was just a big show. And as a result, one of our detectives that was on scene, he brings it to the attention of the commander out there. He says, look, we're violating everybody's rights. And as soon as he did that, he got back to the station. He was placed on desk duty for the last 6 months, and now he's been transferred back to patrol and lost his detective position. So what it came down to, you don't question the chief of police. You don't question anything. To me, it's no longer, this is the disturbing thing for me, Randy. It's no longer about enforcing the law. And I can tell you that firsthand. They do not care what the law is. They only care about, you have to take orders. If you don't take orders, you're going to be out of there. And that's the path that I feel like I'm going back down. But you know what? It's gotten to the point for me, it doesn't matter anymore. I'm going to do what's right and let the chips fall where they're going to fall. It doesn't matter to me. I will not compromise my integrity any longer there.
Well, we're grateful to have, somebody that thinks like us about those kinds of things on our side, but that's on that side. So you're getting us, firsthand information. By the way, I want to, announce that we have Kelby and his advocates on the line with us as well. They've tapped into it, so we've got quite a few other listeners coming in through them, and we're so glad to have you guys join up with us here at 42 Action. So this is about, it isn't about separate groups. This is about bringing us all together so we can all learn from this and move forward and try to figure out what we can do. I do not want to be the only one to ask questions. I'm going to go ahead and unmute some lines. And
I have a question, Rodney.
Yes. If you have background noise, let me just state this. Go ahead and remute your line, please, so that the questions get through. Go ahead, sir.
Yeah, this is Ron here in Southern California. All right, Rodney.
We lost you, Ron.
Can you hear me now?
Yes, go ahead.
Yeah, Rodney, I met you before through Fred and Nina. You just mentioned something. I'm curious to find out how I do it. How do I go after a judge in physical capacity?
Okay, I wouldn't really recommend that. It's a huge uphill battle because the judges have, first of all, the police have qualified immunity, and the judges have what they pretty much call absolute immunity. So when I was really at the start of litigation, I knew of somebody we went after. We actually sued 5 judges, and none of them went anywhere. So to sue the judge is not the way to do it. What you got to do is you got to make the judge rule according to law. And the way to make the judge rule according to law is to understand what the rules are. Because once you understand the rules, well, he has to abide by the rules. And then also, here in California, what I just recently did, there was a judge that wasn't ruling according to law. So everything is about building a record. So oftentimes you'll find here in California that there is no court of record. Okay, especially in Los Angeles County, there no longer is transcripts going. There's nothing actually going. So you have 2 protections. You either bring a bunch of people with you and they write affidavits and put it on the record, or you have to pay about $400 every time for a court reporter. So that's pretty much your 2 options. So to answer your question directly, I wouldn't suggest suing a judge. I suggest making him operate according to law by the rules, and then you'll find your remedy. That's the simplest way to do it, and that's by building a record.
Thank you.
You're welcome.
Next question.
I have a question.
Yes, go ahead, Lorna.
So you hit the nail on the head about the personal capacity, and I just sent you, Randy, I just sent you a letter that we sent to the CFO of the court system so you can see how, just for the template and how to do that. And once you put them in their personal capacity, how did they respond to that? I mean, a lot of them think it's a joke.
Well, I think, see, to me, I can't, okay, as far as hitting someone in their personal capacity, oftentimes, like, for example, I sued the city. When I sued the county out here, I sued the county, and this is Los Angeles County Sheriff, one of the biggest counties. I sued the Los Angeles County Sheriffs and all the deputies in their personal capacity, but what you found is the Sheriff's Department picked it up. And they picked it up and they paid for the deputies because they take responsibility. So at the end of the day, I would have liked to have hit their personal pockets just to send a message, However, at the end of the day, you know, you just want solution to resolution, and then it backs them up off of you. So it's a very simple process to sue them in their personal capacity, because that's pretty much just in the caption, the way you do it, and then you just let the chips fall where they may at that point in time.
So you're saying you were not successful in getting anyone in their personal capacity?
No, because the county, like I said, I sued them in their personal capacity, but the county paid the entire settlement. So no, none of them had to pay.
So you weren't able to attach any of their personal assets. Okay, thank you.
You're welcome.
Hey, Randy, do you mind if I open up my Q&A for anybody that wants to come in and ask?
Yeah, no, go ahead. Please do.
Thank you. Guys, I'm going to press the Q&A button if you have a question for Rodney.
Q&A session started.
*6 on your phone, *61, *61, and you can come into the queue, and I'll announce you to come in and be able to ask Rodney a question.
Do you have one?
This is Dave.
Go ahead, Dave.
Rodney, I spoke to you last night. Thanks for the conversation.
Hey, Dave.
I went to my court case this afternoon, and the judge would not let me know whether it was a civil or criminal matter after asking her repeatedly. And basically she just denied everything I had to say and just played games with me. I guess I'll say it that way. I know talking to you last night, you said once you're in jurisdiction, it's hard to tiptoe out of jurisdiction. That's what I was trying to accomplish, and I guess I didn't. I have a trial set for April 6th.
Okay, that gives you plenty of time. Say April 6th is several months. I mean, not several months, but what is that, maybe like, that's
5
like
weeks,
about,
whatever it is, 6 weeks.
Yes, that gives you time because, and a little bit about Dave. He was, from what I recall, Dave ended up with some type of traffic accident, and then the police has come by and give him some sort of traffic citation. Isn't that correct, Dave?
Yeah, careless driving because I told the cop he's not going to put words in my mouth.
Okay, so one of the things exactly like I was telling Dave, and so here's the thing, and to give you a blanket thing, okay, traffic. When we talk about traffic and we talk about court, there's only two types of actions that can take place in the court of law: civil and criminal. All this other stuff it doesn't even exist. They're just making it up. So if it's civil and criminal, that's the only two actions. If it's a civil action, you'll know it's civil because you'll receive a summons and you'll receive a complaint, and it's supposed to be verified with a summons telling you to come to court on a certain date. Okay, that's a civil action. If it's criminal, it's criminal, and that's a. So if it's a criminal action, if it's a criminal action, there's normally going to be an arraignment there. So if you're entering a plea of guilty or not guilty, and it's not a criminal action, therefore we can't proceed. Okay, so I'll give you an example. Wait 1 second here, guys. Getting a call. 1 second. Okay, so if it's a criminal action, you cannot enter. Okay, so if we're moving into a criminal action, they want you to enter a plea at the very inception. Now, what we need to deal with here, especially in traffic, they're asking you to enter a plea. So if I know I'm going into a criminal jurisdiction, here in California, you look at the criminal rules of procedure. Once you look at the criminal rules of procedure, it's going to clearly define what is required for a criminal action. If that doesn't exist, therefore, the first thing we attack it is we put in what they call a demur. And that's exactly what I was saying at the very beginning. A demur is a motion to dismiss because all the elements are not necessary. And like what I can tell the entire world, I know this much. We account for in America 25% of the world's population that is in prison. That is millions of people. Okay? California law, I don't have the site right now, but it says for there to be a crime, it's a two-part thing. There needs to be injury, loss or harm, and there needs to be criminal agency. Criminal agency is intent. So if you don't have injury, loss, or harm, and criminal agency combined together, therefore you lack a crime, and every case should be dismissed. So what I state to you right now is 80% of the males that are in jail right now are in there for narcotics, and there is no injury, loss, or harm. So what does that say about the fraud in the system? Now, what does that say about all those attorneys who represented those individuals? So until we learn the rules of the game, and the rules are the criminal code of procedure. If we're in criminal court, it's the rules of evidence. Yes, the rules of procedure and the rules of evidence. And then they have the rules of court. Once you learn those, you'll be able to really vividly see what's going on and how to seek remedy. That's the only way that I see that it can be done. Okay, so Dave?
Sir.
Okay, Dave, and to answer your question, where you're at right now, she's trying to go to trial and whatnot. You got to back this up, and it's no simple answer. Somebody would have to take a look at it for you, but you would need to go in there. The solution would be to go back in there and to do a motion to, I would do a motion to quash that original, quash her ruling. The original, when they enter the plea for you, probably on the record, it shows them as entering a not guilty plea for you. So once she enters that not guilty plea for you, you have to start it all back over and do a motion to quash. Because what's happening is when you're standing there talking in court, there is no record going, and the only record that is there is the docket. So you got to pull that docket and see what that docket says, and that's the way you start. Now you have to correct the record on that docket in order to find remedy.
So I've got to go back and order whatever's on that docket. Is that what you're saying?
Yeah, you can order it. I mean, every court is different. If I believe you, I remember you were in Colorado. Every court is different, but you go over there. I know in our courts over here, they have what they call a file viewing room, and just go pull all those dockets. And oftentimes you can, most of the courts you can also look up online, and you can just at least see what's there, and then make sure you pull all those dockets. And then that's how you can start to building your case, and then that's how you have to file different motions into court to clean the record up and make the record reflect correctly.
Another question to add into that. A couple of colleagues here went with me, and I got a call a little bit ago about because of their experience wanting to show up in court under special appearance.
Somebody got there.
Can that be done?
I don't deal, when we talk about special appearance and all that, I don't deal with that. I mean, I don't know. That's just not a technique I like to use. I just walk into court and I apply the rules. I don't get into any of these, anything that could be theory or anything that I can't prove. I simply walk into court, and either you have the elements or you don't. So, like, for example, if you have me in a criminal court and I hurt somebody, if I rape somebody, kill somebody, well, you got me. But if I didn't harm nobody, I'm going to fight you to the end, and I'm going to get this case dismissed. And I am not letting you enter a plea for me. I will not let you enter a plea. Now, remember this. The judge can only enter a plea for you if you stand mute. But if you're not standing mute and you're asking questions, by law, they can't enter a plea. Now, when they do, because oftentimes they still will bully you, that's right as soon as they enter that plea, I'm doing a motion to quash that judgment, and I'm going right back in there to go make a record. And I'm going to bring all my friends with me. Either a court reporter or I'm bringing all my friends with me so we can do affidavits, or if the court reporter is there, I can go by myself.
Well, the plea is not guilty. Which I submitted a couple of 2.5 weeks ago. So today when I went in, I let her know that I don't grant her jurisdiction, any jurisdiction I may have provided her a couple of weeks ago. I hereby revoke and rescind moving forward. She didn't want to hear it.
Yeah, and there's probably no record of that. See, you said it, but there's no record because even here's the reality. Even when you're in there with a court reporter and you have transcripts, in order to get it on the record, you would have to have the court reporter there. She makes the record. Then you have to order the record, and then you got to do a motion to void and vacate whatever he did, and then I would file the transcripts as an exhibit to my motion. So it's a lot of work that you have to do. That's the only way to clean the record up once they confuse the record. You understand what I'm saying?
Well, exactly. I heard what you say, but that's something in-depth studies I'll have to get involved in. I guess that's about all I can say. Exactly.
Yeah, I know I may be speaking above some of your heads. Anybody that has experience in court, it's a very simple concept. But that's one of the things. This isn't going to happen overnight. But once you see it and you get put in the right direction, it took me only about 3 months to figure it out. Where I was studying constitutional issues for about 5 years. But once I saw how this worked, it was quick and simple. And there's tons of practice guides out there which can assist you in writing your motion. So you're not all on there's templates out there for you.
Okay, I appreciate it. Appreciate it, Rodney.
You're welcome, sir.
I have a question, Randy.
Yes, go ahead, please.
All right, I just unmuted the line from area code 405. If you could go ask your question. 405 area code. You just got unmuted to ask your question.
Thank you, Kelby. I spoke with you.
Can't hear you.
There we go. Sorry.
There you are.
Rodney, last spoke with you at Fred's last convention there in Las Vegas. Ston on Oklahoma was about a policeman at Oklahoma Highway Patrolman at a checkpoint pulled me out of my car and arrested me for that. You had stated to file a grievance on that, and naturally the state came back and said that he did no wrongdoing. My question, I have two questions, is there a way for us to continue that, and or I guess are you still assisting folks? You may have already addressed that. And the second question in line with that, are we still doing we study law things somewhere? How to practice in court? How to I'll yield.
Okay, just to make it like with Fred and Nina, I used to show up and I used to come and learn just how you guys would learn. So I don't believe Fred and Nina. I'm not sure where they're at right now, and no, they're still not doing we study law. One of the things that I'm looking at doing right now is to have workshops where we can do this. I can't do paperwork. I can't practice law without a license. That will get me in trouble. I'm simply here to, once you guys are shown how the fundamentals of how the court works, it would be very simple for everybody to do their own paperwork. I think everybody can help each other through it. So I am in the process of trying to put something together where we can actually have workshops. Maybe we might have to travel state to state and get as close as we can to people, or even webinars where we can sit there for a whole day with the documents, show you what's going on, and that's going to be the most effective way we can do this, and waking up the people. So that's what my future goals are here.
To being a part of that. Thank you, Kelby.
Thank you, buddy. Again, if anybody has any questions on my line, just go ahead and press *6 and the number 1. Press *6 and the number 1.
Any other questions on our side while we're waiting on Kelby's side?
I do. Actually, it's a comment and a question both. What experience do you have with Federal Rule 201, Federal Rule of Evidence 201? What's your success rate with that if you've used it? I'm having good success with it.
I know, because I can see it in my head. What is Rule 201 right at the top of your
Okay, I have a document I'm sending you, Randy, and I'm going to read off of that. I'm not going to give you any names. I've changed it so you can use it as a template. Mandatory judicial notice. Federal Rules of Evidence 201 A, B, and D is mandatory judicial notice. And basically what it does is it gives mandatory judicial notice of adjudicative facts for which no controversy exists. In other words, in a court case, it's been my experience, and I've been in the court for way too many years, and I'm going to count. But what I've seen is that they take no cognizance of any kind about a fact or evidence, at least in Alaska, and we're talking rogue court. If it's corrupt, this is the place. So the way to get them to take judicial notice is a fact that is not in controversy. For instance, let's say you've got a foreclosure and you've got a 1099-A, which shows that, which is very unusual, but they send you the 1099-A saying that they actually filed for the abandoned funds, which shows that they actually not only filed, but they received the money, therefore the house is paid off. That would be an undisputable piece of information that is public knowledge because you have the document in your hand. Therefore, it's adjudicative and not just hearsay, where they try to use hearsay with all evidence that you file in the court. This way, they're not able to argue that. It's evidence, and that's the end of it.
Okay, I got you, but yeah, that 1099, I think now I am familiar with 201 now. That's okay. As far as taking judicial notice, certain things that you could take judicial notice of would be the Constitution or a law. That's something that is undisputable. We can't dispute it. Maybe there's a statute, a law, and you want the court to take judicial notice of this, and nobody can dispute it. That's in the capacity that I would be using it. When you're talking those 1099As and has the loan been paid and what's going on with the trust and all that, that would, in my personal opinion, would not be the proper way to use 201 and judicial notice.
Let me read the rest of it. It says 201 of facts that are not subject to reasonable dispute, in that it is generally known within the state and capable of accurate and ready determination by resort to sources, and this is the key, to sources whose accuracy cannot reasonably be questioned. The originating source's accuracy cannot reasonably or otherwise be questioned, as those sources are the unquestionable sources of the facts here. So it's at the state and the federal level. It's worked here. I don't know that it'll work everywhere. Anyway, that was just, I thought, had you used it, what was your success rate? And I yield.
Yeah, and to answer your question, as far as let me think as far as when I used it in the state case, I'm sorry, in my federal cases, I had 2 Title 42s, and another one was the second one where they let them out on qualified immunity, and I just ran up the energy to keep fighting it, was when I was in the courtroom one day, and I was there assisting some other individuals, and the judge just happened to kick us all out of the courtroom. And then as they kick us all into the hallway, the deputies don't like where we're standing in the hallway, so they can just keep pushing everybody down the hallway. And at one point in time, on one of my friends that was there, they actually pull a taser out, and they're about to tase him in the hallway because he's not moving down the hallway fast enough. So what the deputies do, one of the deputies sees me recording I'm about 40 feet away from the incident, and she sees me, and out of nowhere she just comes and snatches my phone out of my hand. And she arrests me for contempt of court while I was in the hallway. Well, one of the things that doesn't apply is you can't have contempt when you're outside in the hallway and you're not even disturbing the court proceedings. So one of the things that I did, I took the rules of court, and then I took the penal code section, and I made the court take judicial notice of those, showing what it was, and that was actually accepted. And that was an effective way that I was able to use it. I'm not saying it's not correct to have it take judicial notice of the 1099, because I'd have to look at everything in context. But and maybe it could be, maybe it wouldn't be. We'd have to study that. But that's the way it was effective for me. Just taking a statute, code, rule, regulation, something that is totally undisputable, you put it on the record to make the court rule one way or the other, or to show them your argument. So that's the best I can give you right there.
Excellent. Thank you.
Oh, you're welcome.
Shelby, do you guys have questions on your side?
Yeah, I do. Hold on 1 second. Tina, go ahead.
Hi. On regard to the judicial notice, would that be effective if we asked them to take judicial notice of a case that's already been ruled on, such as in a foreclosure notice asking for judicial notice of, like, the Credit River decision?
Okay, so if I'm correct, you're asking on another court, maybe another appellate or Supreme Court ruling, and would that be appropriate to take judicial notice? And I would say yes. I would do that.
And how would you ensure, if the judges ignore that in your case, how would you go about it in appeal?
Well, the first thing, when you're gonna file a motion to have the court take judicial notice, and then the other side is going to oppose it. And if the other side doesn't oppose it, then it should automatically be accepted. So.
Well, it wasn't.
Well, did they object to it or not?
The judge ruled, in my case, ruled against me and dismissed it without leave to amend. And we had put, the Credit River decision and another Supreme Court decision in there. And the other side did not oppose that. But the judge, just went ahead. Now I've filed for an appeal, but I was unsure of how to use it in an appeal.
Okay. You're saying, okay, first and foremost, okay, you said why were you using that Credit River decision? What were you trying to accomplish?
Well, because part of the whole deal is the loans are never true loans, and when you sign those papers, it's for a loan that I have received, which you actually haven't when you get it. And that Credit River decision was specific to saying that these loans, that it was all fraud. Everything that banks did was pretty much made up. Now, whether that's because the judge in that particular case was murdered 6 months later, I don't know. Whether that's why they ignored it or not, I'm not sure.
Okay. Now, one thing that I want you to be very cognizant is words and their meanings. Law is very, very technical. You can lose a whole case or win a whole case by one word that you say. And when you even start saying loan, be very careful with a loan because, like, for example, if I were to walk up to you as an opposing counsel and say, did you receive a loan, what would be your answer to that?
What loan?
Okay, good. Now, that's the start of it. So you have to be careful on how you're doing your pleadings because and what you're arguing because you can just take the stance that, maybe that, and one thing that I use very effectively in a state case on a home is, that because you have to understand the way the homes are being moved around and the way they're being sold. It's not foreclosure type things. Especially here in California. I can't speak for the judicial states. I can speak for the non-judicial states, and these are just deed of trust. So they're saying they're pushing the house around based on that deed of trust. So right as soon as they push that house around on the deed of trust, in order to cancel out that deed of trust, you have to form your pleadings properly and show that there never was a loan. And what you do is you just come in there and say, I never even received a loan. And then when attorneys come in and they start talking about loans, there's various strategies that you can use to make sure you stay off the record. I don't want to get all into the homes because it gets very, very complicated. But we've had success with homes, and there's it gets very complicated. So that'll be a whole course in itself. But as far as that's about the best I could tell you right now. I don't want to get into a lot of detail on the homes, but I know that's a pressing issue. So later on, that'll be something that we'd be bringing to everybody. And just to let you know, I'm in the process on my home also. I've had it for I've had it for a long time, and it looks like I'm going to have great success right here. It's just a matter of getting the judge to straighten up. Once we get the judge to straighten up, we're already pretty much done because the original lender on my home, which was KB Mortgage, never even showed up in the case. So now you just have MERS and all the rest of them there saying we're here. But once the original alleged lender that was there, once he disappeared, pretty much the case is already over. So I plan that once I finish this case out, I will share all that information with everyone. But I don't want to go into detail until mine is done. I've seen others done. I can show you others that have been done. But until I do it myself and complete it, I don't like to talk about it too much into detail.
Excellent.
Okay.
Probably too late for me by then, but anyway, I'll keep fighting and doing what I can, and I'll re-bring that case up anyway.
Yeah. I'd have to look at your pleadings and see what you're pleading and see why it's happening what it is. And one other thing I want to touch on, when you sit appeals, when you talk about the Court of Appeals, you have to realize you can't bring up a new issue in the Court of Appeals. So if your record, which is very, very important when they're making bad decisions and doing various things in the lower court, is very important to state in the lower court before you go to the Court of Appeals. So if the judge made a bad decision at the lower court, which I suggest a motion, what I would do is a motion to void and vacate the judgment, and then now I want him back on the record and explaining what he's talking about. Because what you're going to find, if you have a really good, solid argument, you'll find that the judges will not confront the issue, and they'll say, a lot of my rulings, he'll just say denied, or he'll just say denied. Well, one of the things in law, and under the rule, under his judicial canons that regulate him, he's required to give you a ruling and a description why he did it. But you'll find if he can't explain it, he doesn't want to talk about it. He'll just try to bully you and keep pushing you down the road. So when the solution is, as soon as they try to bully me and push me down the road, I'm throwing it right back in his face, and I'm doing a motion of void and vacate, and I'm going back in the court, and I'm going to make him explain what he's talking about, what a court reporter does. So it gets expensive, and it's a long fight. Guys, this by no means is litigation easy. No means is it easy. You're not going to get the huge payouts necessary. You're not going to get huge payouts. It's not going to be that. The reason I kept doing it, and the reason the home is a big one, but the reason I would do the federal litigation and the civil rights violations or whatever it may be is because I just want to prove I'm right, and I want it to be right, and I have to settle it. For me, I have to close the door, and I want to settle the score. So that's what it means to me. That's why I keep fighting it. But I probably spent more money than I got back in return at the end of the day. And then for all the time and energy, I'm telling you, it took me 2 years of my life to do that. I was doing both of them. I was doing two civil rights cases. I was doing two civil rights cases simultaneously, and it took me 2 years of my entire life, almost every day coming home and having to study. So it's exhausting. But if you want to fight for the truth, and I think that's what most people are here to really look for the truth and understand it, then that's the reason why I was in a fight. And that's the reason I'm here. I want to teach people how to do it.
Tina, sorry I muted you out there. It was an accident. I was trying to go for a different button. Do you have any other questions?
No, I'm just going to keep fighting myself as long as I can. I'm in a state case as well as the Fed case and all the other stuff. So, I'm trying to figure out what to do by April 1st, which is the next sale date, but I'm not.
Oh, your next.
And I
when's your
keep going to the,
When's your next sale date?
April 1st.
And I'm sorry, are you in California?
Yes, I am.
Okay. Why don't you can you later on get your number over to Kelby?
Yeah, I'll hook you guys up.
Okay.
Yeah.
Maybe we might be able to, maybe we'll be able to show you something that may be able to help you out.
Okay. I've got a hearing on the state case, which is just FDCPA against the trustee on March the 25th.
Okay. Well, let me see. Maybe I can share some information with you that could help you. So I'll get it from Kelby later on, your information.
Great. Any little bit will help. I appreciate it.
Okay, you're welcome.
Next question up.
Yeah, we got another question. If you want somebody on your side to go or what have you, just let me know.
No, if you got one, go ahead. Jump in.
Okay, area code 781, you have the floor.
Hey, good evening, everyone. This is Vital from Massachusetts. How you doing, Kelby? How you doing, Randy?
Great, thank you.
Hey, Rodney, good work, man. Proud of you. That lady was talking about the Crow River decision, but I believe that decision has been overturned. Plus, it was done by a justice of the peace, and eventually I think that justice of the peace was sued after that. So that may not be a good case to bring up. The other thing to expand on what Rodney was talking about, when the judge gives you a decision, just a denial or anything like that, you can go back in and file a motion for a memorandum of decision, and they have to give you the decision in writing.
Well, and that's right, but sometimes you can't even get them to do that. They just, I found things that it is, what they've even done in my cases is you'll put in a motion. Like at one point I put it, when you guys go online, or if you want to, when you go into Pacer, and you'll see it's the case. Actually, I did it in both cases. One was Rouzan versus Waylon Thomas, and the other one, that's the LA County one. And the one I had against San Bernardino was Rouzan versus Lorena Dorda. And what you're going to see is, I mean, I saw so much fraud where you had the perfect pleading in, and then the judge would, they would reclassify your motion. So you put one title on it, and the judge is like, I actually thought it was a motion to disqualify me, and then they'll send it to another judge and then dismiss your whole motion. So they would, and then we would go back and put in a motion that the judge is falsifying the record, and it just went on and on and on. So I just found it's almost impossible to get an answer out of these guys sometimes. Almost impossible.
Oh, yeah, we're going through that right now. We're challenging jurisdiction, and they keep manipulating what we put in and making decisions on the other side's filings, and we're just ignoring all that and just keep coming back to jurisdiction. And we just actually prepared the paper today, probably file it tomorrow. And now we're mentioning sanctions on the judge for not proving that, he has personal jurisdiction.
Wow. I've never even thought of sanctions against the judge. Have you seen that work before?
We actually did it with the other judge, and he left, and this one came on.
That will be a good strategy. I never thought of that.
Yeah, we're trying.
That would be an interesting. I mean, the main thing, what I can say is if you can get the ruler and the judge to act according to law, well, I think once we pinpoint our arguments and everybody really understands what they're arguing, and that's just bringing your case according to the rules, all you got to do from that point is get the judge in line. If we can get the judges in line, then at that point you should get an appropriate ruling or a fair ruling.
See, like you found out with the police department, a lot of officers without oath of office. In the judiciary, it's the same thing is happening, and it's even easier for them to hide oaths of office or not have any, because it's not done publicly like the police department. Sometimes they have a swearing-in ceremony, and everybody takes an oath, and then it's supposed to be done in writing. But judges, a lot of times, it's done without the public even seeing it. And that's, what we're kind of going after here is, having him show that he has an oath of office according to the Constitution of Massachusetts.
Well, see, I agree, but I look at it like this. Okay, I don't really care if he has an oath or not, because that doesn't really matter to me. What matters to me is that he rules according to the rules. So I want his rules to be in line with the law. So if I bring a proper pleading, for example, say it's a libel and slander case, and libel and slander, let's go to defamation of character. That's a simple one. So defamation of character, as long as I bring all four elements into court, I don't want him dismissing my case when the attorney brings his demur or his motion to dismiss. Like oftentimes what you'll find is the judge, the other side will not confront your issues. I'll bring my motion and bring it, and then the attorney, like what I saw in multiple cases, the attorney will say, well, Mr. Rouzan didn't bring all the elements. Well, one of the attorney's duties is to say, I didn't bring the elements, and he's supposed to point out which elements I didn't bring. If he fails to say which elements I didn't bring, therefore his motion should be turned down. But you'll find the judge still ruling in their favor. So his oath at that point really doesn't matter. What matters is he's violating the rules for a demur, because at the stage of a demur, no one can bring new facts into a case. As long as I've made the initial pleadings and I've pled what they call it a prima facie case, as long as elements that is necessary. And let me break this down for police work to make it real simple. The easiest way, and I can tell if I go to the police side instead of staying on the law side, for example, we call it a 459 in the state of California. A 459 is a burglary. So what's required for a burglary? A burglary is someone breaking into a location and there to commit a felony or some type of theft. Okay, so if I find somebody that he goes into a house maybe to commit a rape, but he broke into a locked house, therefore I have burglary and I have rape. okay, because he broke into the location to commit a felony. So all the elements are necessary. But if he maybe just walked up to the lady outside, but he didn't break into the residence, we don't have a burglary, but we still have the rape. So at that point in time, if you were to bring the burglary against me and the rape charge, my attorney should be objecting because I don't have all the elements necessary for a burglary. So as long as the elements are there, that's fine. But if the elements aren't there, you can dismiss the case. But in order for me to bring that demur, I have to point out what's missing. But which are oftentimes is that you'll find the attorneys will just say, well, Mr. Rouzan doesn't have all the elements there. Well, what elements am I missing? And if you don't explain what elements I'm missing, based on the rules, the judge has to rule in my favor. And if he doesn't, that's who, forget about the attorney, go after that judge. And so really the oath doesn't matter to me. I don't even care if the police officer has the oath. Just he needs to rule according to law. He needs to act according to law.
Yes, that's true, but that's when you're bringing the action. But this action is being brought against me. So if I can knock the judge out or the plaintiff for lack of standing to begin with, that works in my favor.
Yeah, but I just it could, but it may work, but I've never seen the guy doesn't have an oath, so he can't proceed. I've never seen that argument win.
Yeah, we're not really challenging the oath. We're just challenging that he doesn't have personal jurisdiction, and then he has to show that he does.
Okay, and
so
you're
we'll see
saying
what happens, but we've been challenging it from the beginning.
Okay. Yep. Well, and as long as you challenge it, and if you can prove and as long as you're creating a good record, like you were saying, and you keep following your motions, once you set a good enough record and you're just not finding resolution, then at that point in time you can go to appeals, but you're going to have to pinpoint your argument.
Yeah, interlocutory appeal probably. We'll see how it goes. I'll let you guys know.
Mm-hmm.
Hey, keep up the good work, and I'm proud of what you do, and thank you, Calvi, thank you, Randy, and good evening, everyone.
Thank you.
Thank you.
Okay,
Any
Randy.
Yes,
Randy,
sir.
I can give you guys about another 15 minutes here, and then I'm going to have to get off this line, okay?
Okay, sounds good. Any questions on our side?
I have a comment.
Go ahead.
You nailed it with the judicial canons. Rarely do any attorneys ever go there. In fact, I've never seen one go there in over 20 years. The judicial canon is holding their feet to the fire. You're basically telling them if they don't do what they're supposed to do, that you're going to enact what those judicial canons say you can. And so you sit up and notice. In fact, they notice quite attentively. And then the oath of office, that's pretty much across the board. Like it or not, we're in commerce, whether we want to be or not. And in our state, there were 3 of us that went to the personnel office of the state, administrative offices for the court system, actually the whole state. They have offices, office of oath on file, but none of them are signed, including the Supreme Court justices. I yield.
Okay, thank you for that.
Hey, I'll ask a question, Randy.
Yes, go ahead, Brad.
Yeah, Rodney, hey, I appreciate the time tonight. Very valuable information, and congratulations on your win. As a law enforcement professional, what advice would you give to people who are pulled over on the side of the road? What's the proper conduct? What should they expect? What should they do? What shouldn't they do? Are there some severe do's and don'ts in that scenario?
Now, when you're talking about you're talking about a traffic stop. Is that what you're referring to?
Correct, yes.
Me personally, I don't, no arguments with the police. I don't do it at all. And I'll give you something that happened to me, 2 weeks ago. I got pulled over, and normally I don't get tickets. I can always badge them, but and that's what most police officers normally do. But this one, I decided to go ahead and take it. It was just a simple. In California, they can give you a citation for no seatbelt. So one of the first things I said to the police officer He comes back to he comes up and asks me for the things he's asking. I just said, what am I being pulled over for? That's the first thing I would just say. And he's going to tell you, don't admit to anything. Don't say you knew you were speeding or anything. Just say, what am I being pulled over for? That's it. And then what I threw out to him, I said, sir, do you have reasonable suspicion or probable cause that I'm committing a crime? And he says, no. And I said, why are you pulling me over then? And he said, traffic. I said, okay. I didn't ask another question. And he goes back to his motorcycle. Now, I know he's recording everything. Now, the next thing, then he comes back and I says, what happens if I don't want to sign this thing? And he says, well, that's telling me that you want to go to jail right now. And I said, sir, please don't put words in my mouth. I said, I just asked you what happens if I don't sign this. And then he says, well, I'm going to take you to jail. And at that point, I went ahead and signed the ticket. Now, the reason I did that, because if I wanted to take him to court later on and sue him, I already set the whole deposition up because, and the other thing I asked him, I don't know if I said this already, but I asked him was the recording, and he said yes. So what I could do is, I know that's discoverable information. I could actually probably get it through a public records request and get that tape, because by him stating that, to briefly explain, okay, the way it works in California is the police officers under Penal Code Section 830.1 is our power and authority. And then the California Highway Patrol is under 830.2. So what it states in the Penal Code, that's our powers and authority. We only have the right to stop and detain when we have a public offense being committed. Okay? So a detainment is to stop and detain because we believe a crime is afoot. And then we have probable cause. So we have reasonable suspicion and probable cause. So we can first detain you, and then when we decide that we're going to go ahead and arrest you, that means we have more than enough to believe that you're the one that actually did what was being done, the crime. So if he doesn't have a public offense being committed in his presence, therefore the stop is automatically illegal. So what the police officers are often going to tell you is, well, I have traffic, or you did traffic. Well, traffic isn't a public offense. Okay? Now, the vehicle code gets a little bit confusing because I'll throw a few more numbers out there to you. Penal code number 16 is going to say a public offense includes a traffic. But however, penal code, it's either 67 or 69, says that a public offense has to be triable by a jury, or you can enter a guilty plea and then waive that right for a jury. So if I don't have a trial by jury, therefore it's not a public offense. That's going to be my first argument in law. Now, the second thing I'm going to do is I'm going to pull the vehicle code because he feels his authority derives from the vehicle code. But once he feels his authority derives from the vehicle code, I'm going to pull up California Vehicle Code Section 4300.5, and within that vehicle code, it's going to tell you under what authority a police officer can pull you over. And for one, he needs a warrant, and then there's 5 other sections in there. DUI, if you're blocking a roadway, if he feels you just committed a crime, and etc. So you can look it up for yourself. If none of those elements were necessary, such as he's going to say, well, I pulled you over because you were speeding, or the red light, he just admitted in law that his traffic stop is illegal. Therefore, you'd already be set up for the civil rights violation. So what I would do is,
you know, if you have a tail light out or something like that, that would all fall under similar circumstance.
Yes, and what state are you in?
I'm in Florida.
Okay, so Florida, I'm just stating for California. So yes, at least in California, and you find that all the states are the same. They don't have no business pulling you over for that stuff because those are just supposed to be things that are regulated by the DMV per se. It's not what we're doing. See, we're using our police powers to enforce administrative DMV regulation, which is illegal. So once you guys effectively see how it's done, what I've seen is, and one of my mentors through this, he'll set the police officer up by just asking questions, and he's getting him to already state that. He's getting him on the record to state his position. Then he'll go all the way through traffic court. And once he gets through traffic court, basically he's using that as a deposition against the police officer, and he doesn't even know it. Then he'll take all those transcripts and go into the federal court and sue him based on what he already said, because he's going to say he pulled you over. Mm-hmm. Yep.
Is one?
Well, he settled the cases. I don't call them necessarily wins, but you'll settle the case. They'll settle the case because they won't want it to go to court.
Well, what if the circumstance is a little bit different? Like there's a situation that I know of, wasn't me, but it's a situation I know of, where there was alcohol involved, but it was hours earlier, so it's right on that borderline. Probably not enough to test in the range that would get anybody concerned, but yet probably would test a little bit. So it had been 2 or 3 hours before the last drink was had, and it wasn't. But you suspect that the officer pulling you over is going to want you to blow or draw blood or something like that. How do you walk through a landmine like that?
Like I said, what I've seen when they pull you over for the DUI, I've seen them actually hold people down on the table and draw the blood from them. I'm gonna object to. Me personally, I would object to giving up anything. But if they're going to force you to do it, go with the program. There's no need to fight with it right there, because at the end of the day, even when you call me in there for DUI court, now we're still going to be entering a plea, and I'm going to object to it because there's still no victim. So if there's no victim, there's no injury, there's no loss, no harm, those court proceedings, I'm going to stop them at the arraignment, and we won't proceed past that point. That will be the way. That's the way I'm going to fight that DUI.
And even if the blood shows that it exceeds the legal limit because it was taken under duress and there was no warrant or anything like that, does any of that come into play?
Well, yeah. Well, if you're there's a whole lot of different ways. If they're bodily intrusion and doing all that, and they're holding you down, that's one course of action. But me personally, if I was pulled over on DUI, my main thing is I want to get rid of this case. So when I want to get rid of the case, I'm going to resort right back to where's the injury, loss, or harm, and I want this case dismissed. That's going to be my angle of attack. That's strictly how I'm going to get it, because I want this thing out of court, and I don't want to keep going back and forth to court.
Well, are there any resources to study up or tap into that you'd recommend on that?
Oh, we have. There's tons of stuff out there. Matthew Bender puts out practice guides because, like I'm saying, the first thing that you're going to need to do is in state court here in California, we have the California Civil Code of Procedure, and we have the Criminal Rules of Procedure. We have the California Rules of Court and the Rules of Evidence. And in then we have the Federal Rules of Procedure if you're in federal court, and the Federal Rules of Evidence. Once you understand all the rules, so like, for example, if you're bringing me into a criminal court, and the way you know I'm coming into a criminal court is because I'm entering a plea. If I'm entering a plea, we're in a criminal court, look what's required for a criminal action. If those elements aren't there, such as half the time in traffic, there's not even a district attorney there, or city attorney. If nobody's over there, now you already start to see the fraud. You can see it. Hold on, you guys don't even have what's required for a criminal action. What are you asking for a plea for? We need to back up. That's my point of attack right there. Always challenge it at the very inception. That's it. Okay. Now, as far and to answer it a little bit better, what we do is I have tons for every single case. We've been to the law library. So I've been in the law library, and I downloaded every single aspect that can almost happen to you. And I can just go in there, and I have it in a Dropbox, and I can type up whatever it may be. And then there's a whole practice guide. And what you're going to find, these practice guides, the practice guides explain every single thing that possibly can happen in a situation for a certain topic. And then they have all the forms for you. So what you'll find is all these forms is exactly what the attorneys are using. It starts off with the heading. It tells you exactly, put your name right here as the plaintiff, put this here, and it starts it off for you, and then it says state your own facts. So that's the motions are already done for you. Then once you have your motion, you attach an affidavit with it, your truth. So now you got the truth. I got the moving paper for the court, and then whatever evidence is my exhibits, and I file that bad boy right in the court, and I'm ready to fight. That's the way it's done. So those practice guides, I could have never did it without those practice guides. Never. It'd be impossible.
Do you spell his last name?
Bender.
Bender. Okay. All right.
Yeah, Matthew and Bender. There's tons of them in the law library, and they're just practice guides. So, but those are the things. Yeah, Matthew and Bender, and there's all the practice guides. So later on, if I look at someone and try to assist them, the main thing that I can do is say, here's the practice guide. Oftentimes they're anywhere between 70 and 140 pages, but you read it on whatever topic it may be. It could be, like I said, it could be defamation of character. So there's an entire practice guide, and it'll give you, I have the ones for, most of my stuff is either for federal or California. I don't have the other states. So you look at that practice guide, it'll give you all the government codes, everything that's being violated. It'll tell you exactly what you have to do. It will even explain to you your case can get kicked out of court because when you're trying to sue, say, the sheriff's department, you first have to do a tort claim with the city. So if you walk into court and open up your claim in court, but you forgot to do the tort claim, that's the reason that your whole case is going to get thrown out automatically. So by us not being attorneys, by us not understanding all the procedures, I don't have the answers. I don't even claim to have half of them. But what I do know is if I have a problem, say Kelby or Randy come up to me, I'll say, okay, let me look up this practice guide. Here's the practice guide. Go read that, and it's probably going to answer all your questions. And that's what the attorneys do. No different.
I think that's the recipe. That's like the cookbook right there.
That's the cookbook. And once you got that practice guide, now you get your rules of court together. Now we're ready to do battle. That's it.
Well, that's a good piece of information right there. I mean, that's worth the whole call right there. Thank you.
Yes. And your law library will have it all. So you can go in there, because I'm not that good at the law library, but there's a clerk there. So walk in there to the law library clerk and say, hey, I got defamation of character, or somebody did whatever. Maybe when my job just started coming after me again, one of the things that I did, I have a practice guide for harassment and retaliation. And I looked up the whole entire book. So as I looked it all up, and then what I did, when I would start sending my notices, I would send my notices, and I would cut the language out of the practice guide and put it right into my notice. Because one of the things that I did, for example, when the chief is harassing me, what I'll do is I document what he does, and I'll say such and such, this happened, this happened, this happened. Then I attach an affidavit to it, and then I attach all my exhibits, and then I serve it on the chief via certified mail. And I said, if you dispute anything that I'm saying, dispute it. And then normally he won't, and then I'll do a 1, 2, 3-step process, and then now I have facts and evidence that I can use against him. So what you'll see is when these exhibits get posted later on, you'll start to see that's pretty much how I took court to the streets. Because once I take the court to the streets and I'm able to go straight after the principal, who is the chief of police, I can avoid the attorneys. And that's what's so effective that we have. Once you learn the law, you want to neutralize the attorneys, because once the attorneys get involved, they start bringing all the legal defenses. So I go straight to that person and say, you did this, this was a violation of this, and they're never going to answer you. Send a notice to a police officer and see if he answers you. He's not even allowed by law to answer you. So you're going to build an entire record on him, and then you walk into court and say, he already agreed to it. Look what it says.
I got a question,
now,
Rodney.
He's already locked up. Go ahead.
Chris Dorner, do you have any knowledge on what happened there?
Yeah, that is I know very much about it. Yeah, I know all about it.
Okay, I'll take that as my answer.
Well, I mean, you have a question about it? I don't mind answering it. Did you have a question?
Just what your thoughts are, because he was telling citizens as he was running that he's innocent, he's being framed, and then they burnt the house down with him in it.
I don't know what happened up in Big Bear and all that. I have my own questions about it, but our chief of police he came from that division, and he was the commander over there, and I believe he was involved in all of that. That was his history. And one thing that I know is when you're a whistleblower, they have to get rid of you. So he was whistleblowing, and when I saw him, he went after the other guy's daughter, and that was his attorney. And for him to go after somebody's daughter, I questioned. I said, why would somebody be that angry at somebody? So that told me something weird went down. And then now, you look at LAPD and they said, we did the investigation and we found absolutely nothing was wrong. Well, if you look at my app, that's exactly what they're telling me right now. So it's kind of, when you investigate yourself, I guess if I investigated myself, I wouldn't find nothing wrong either.
Yeah.
So I believe there was it was a very bad thing what Mr. Dorner did. Nobody should have did anything like that. But I believe certain factors pushed him that way, and he didn't know where to turn. And then oftentimes, my only thing that made me feel good was I said I understand the law and I have a motivation that will never stop. When I knew they did me wrong, I saw how they set me up. They set me up. They put fake stuff out on me. They had me looking like I was the criminal. And the only thing I said, I have to make and protect my record. And that was it. He didn't know how to do that. And one reason I can tell you he didn't know how to do that, because as soon as you tell me you have an attorney, that means you don't know what you're doing.
Right.
So that's my opinion on that.
Well, we hate to let you go because we could keep you for probably another 150
I got
hours.
one last quick question, Randy.
Okay, I can give you. I can go a few more minutes. Okay, I can go a little bit longer.
Okay, good. Okay, go ahead, Kelby.
Buddy, why don't you run for sheriff?
Yeah.
I had seriously considered it, but I don't think I would even get the support. Yet the way to sit, I don't think the time is right. What we have to do right here is all of you guys, however many people on this phone call, is people that are awake, need to learn. I'm very elementary in this, trust me, guys. But all I can do is share with you the information that I have. We walk into the courts together, and we slowly find remedy. I know everybody has all their issues. There's no way anybody can do it for you, but once we learn, we'll move very, very quickly. I'm positive of that. So we just have to figure out here how to get this out to you guys and show it to you guys in an effective manner where you can see it. Once we figure that out, I know this is going to go into something incredible. So I have no fears and no worries about it, But sheriff is a good thing. I would love to be there, but I don't think it's viable right now. It takes too much energy, and I don't have the time and energy to do that right now.
We just need to move him to another state, Kelby, where we're all going to live. And then he can be the sheriff where we're at. How about that?
Well, he does have a point in Texas, being the fact that it's the only state that is built into their constitution the right to succeed from the union. Who knows? Rodney, I appreciate you really from the bottom of my heart. You're a soldier, and you're an integral man that is trying to just do his job and live in accordance to the oath. And you're getting pushed, and you know enough now to stand up and stand back. And so I just pour a covering over you, bro. I pray for you every day, and I thank God for you every day. So be blessed. And know that we got your back.
Thank you, Kelby. I appreciate it.
And these calls too are about your protection. I mean, in a roundabout way, because you're getting this information out to us, and it's not getting closed up like with Dorner.
Yeah, you got it. Yeah. Yep, I understand. I understand what's at stake here. I truly understand what's at stake, because I felt like going under a rock. But now it's like, I'll tell you something. I am a true believer that as far as the energy that you put out, and I believe we're all connected to this earth, and it's a lot of forces going around, dark forces. There's Star Wars and everything else going on like that. So we're here for a reason. And I used to always wonder what my purpose in life was. And when I figured this out, after all the pain and suffering that I feel like my family's gone through, one of the questions I always had, they says, when it comes time to do the right thing, will you do it no matter what? You could lose everything. And I already know what I'll do. So I don't really worry about it anymore. They've already taken everything from me. They already took my job, took everything from me, and I almost lost my entire family over this. So now you've already tried it, and I came back from the dead almost. So I don't have any fear of them anymore. They're going to do what they're going to do, but I've been protected. And for whatever reason, I've been protected. Every night, I'll be out on patrol tonight, but I know I'm protected. And then I've always got what I needed when the time has come. So various people have been introduced to me. Various things have happened. I've got hairs up my back. You know, the hair on my back will stand up and tell me I don't need to be here right now. And I feel that's like that's protection of the higher spirit that's here with us. And it goes very similar. I had seen stories on, if you ever remember, like in The Matrix. And that's one of my favorite movies. The Matrix, and I could tell you, Matrix and Divergent. I guess I'm Divergent. If you see that movie out right now. And
my kids go nuts. My kids go nuts. Every time I watch a movie, I always say I'm Divergent. Like, whatever, I'm that character in that movie. Anyway.
But if you remember Neo, and he gets a FedEx package, and he opens it up and it rings, and then Morpheus is telling him, you go here, you do this. And that's a symbolization of your higher being telling you, move out of here, do this, do that. And it's amazing because the energy, I've connected to certain people who I would have never connected to in the past. So I know all these future battles I have, that's why I try to find peace. Because I'm like, whatever it may be, whatever I need, I'm going to get it when it needs to be here. So if you take away that fear and understand that, just relax. So even the lady earlier who talked about her house on April 1st, just relax, because maybe that's the reason why you're here. Maybe we're connecting. Who knows? But you're going to get what you need when you need it, and just find comfort in that, because fear is going to drive you into insanity.
You know, the number one reason why I see people lose their home is because they quit. They get tired. And it's hard. It's a battle. You know, they just don't know what to do. They don't know what to throw up. They don't know what to throw out, what kind of paper. And I just put on my website, Luke 18, 1-8, Justice Through Persistence. It's a story of a judge who is just hounded by a widow. And he gets so fed up with being hounded by this widow that he just gives her justice. And so you have your model right there for what to do with these judges who are dishonoring their oath of office and so forth. So, again, Rodney, I'm going to say thank you very much and appreciate you. And hope you have a good night tonight. And you are protected, but I guarantee that.
Okay. And Randy, I think I'll take two more phone calls here, and then I'm going to have to go here. Okay.
Okay. Any other questions? He's going to take two more.
Yeah, this is Lonnie in Albuquerque, New Mexico.
Sure,
my son was stopped for DWI in January. He refused the breathalyzer, and so it went to aggravated DWI. Then he did all of the roadside tests, but they never did blood, and they never did a breathalyzer. And they put him in jail, and they arraigned him. And of course, he doesn't know anything about what we're talking about here because he's ignored all the things I've sent him in the email. So at this point, he has an April 23rd court date. He decided that he was going to get an attorney.
Mm-hmm.
So at this point, as I said, they really don't have any evidence other than video of the road test, side of the road test.
Mm-hmm.
So what are his chances of getting out of this?
Well, if you have an attorney, pretty much you're just going to be plea bargaining, and they're going to cut you a deal or something. And what I often find with the attorneys, you'll spend so much money, $5,000, $10,000, and then you're just going to end up selling out anyway. What I see the standard here in California is 3 years probation, normally about 40 DUI classes, and several $1,000s in fines, which could be anywhere from $3,000 to $5,000. And then on top of that, the attorney's going to tack on however much you guys end up having to pay him. So that's what you're really looking at with them. But like I said, it goes right back to DUI. The way I would handle it is if I had a DUI, I'd be challenging it the same thing because, like I said, you're in criminal court. So if I'm in criminal court, can we see the victim? Who's been injured? And if we don't have anybody that's been injured, I move to dismiss this case. And I'm going to stand firm on that. And there's no quick answer because when it comes up like that, you have to realize this, all fundamentals. And it's equivalent, like I coach kids basketball. So I can teach my son or whoever else how to dribble the ball. But he has to practice, and he has to practice. And so when you have a case coming up tomorrow, it's like throwing you in the Super Bowl with the NFL players and you've never played before. You're going to get slaughtered because it's not that simple. So all we can do at this point in time, I say, work it out the best way you can with an attorney, take the attorney's advice for now, or go work out whatever deal you can, and then as we can get the word out to people, then hopefully we'll be able to assist you better. You can come out, you can see the different seminars that it's going to take, you can practice, because the best way for me to teach you, and what I've done before, is I'll put a robe on. I put a robe on, and I got other guys with deputy shirts on, and we stand around you. If you're standing in front of a room of 100 people, and everybody's listening what you're saying, and now you have to go back and forth with the judge. If you haven't had that mock training or mock experience, it's going to be very difficult to handle your affairs in court, because the judge he's going to make sure you know what you're talking about. If you don't know, he'll be able to pick it up the first time you open your mouth. So that's what you're dealing with right now. Unfortunately, there's no quick answer for you, sir.
So when at the arraignment, I guess he should have asked, "Where's the victim?" Right?
Yeah, and then they're just going to say it's the state. And says that he can ask a lot of things, but it's not going to be effective. Because even if he asks these questions, if he's not understanding why he's asking the questions and where is it going, and without the right, first of all, the first thing that has to be done right is the paperwork. So what I would be doing when he walks into court, I'd be doing a motion to a demur, or motion to dismiss, because all the elements aren't necessary. And I'd be dropping those. In California, I'd be dropping the appellate court ruling that says there has to be injury, loss, or harm. And I'd be dropping in a motion in the court, and then I'd be challenging it before the judge. Now, chances are, and see, like oftentimes, because if you're not really confident in yourself, you're going to walk out of there. I could do it, and I could be really skilled and experienced with it, and chances are the judge is still going to run me over. He's still going to run me over. But the reality is, I have to keep going back in there and building the record. Now, to give you guys, this is what happened with, and Kelby knows Mr. Melvin Anthony. He's a really loyal guy. We started this off a couple of years ago. He went in, and him and his wife had an issue down at Orange County Courthouse. So Orange County is a suburban white area out here, and there's not many black folks over there. So Melvin Anthony, he ends up getting into it with the police officers. They end up tackling him, tackling his wife, and after they beat them up pretty bad, they charged both of them with battery on a police officer and resisting arrest, I believe it was. So he finds himself in court. We don't know much, but all we had the power of the people. And we had every day, I was looking at, we probably went to court 10, 11 times. But he kept telling me on a daily basis, he says, me and my wife are not going to jail. Melvin would never enter a plea. And then they enter, vacate out, then they tried to put the prosecutor over him, then we had to go back out, and then this was at the point when they kept doing all this. One day, the judge gave us 2 days break, because every day he used to schedule us to keep coming back in court every single day. So one day he gave us like a 2-day break, and we went out and filed a civil rights case against 5 of the judges in the courthouse. And once we did that, it changed the whole tone of everything. And then eventually they found that they couldn't get this guy to enter a plea. They couldn't put a public defender over him. So eventually they said, oh, the time ran out, and they dismissed his case. But what I saw was on a daily basis, every single time the judge would say anything and he said something wrong, we had notaries there with us, we had a printer, and we had a laptop. So when the judge we would finish the morning session at 10:30 or 11, and he'd tell us to come back by 1, we'd have 20, 30, 40 affidavits, and we'd be filing it into the case. And we filed all that into the case, whatever the judge did or said, and the record was so thick, where they was like, dang, all right, just let it go. But that's what I think that is the power of the people. It's going to take that type of effort. And once you do that, then we're the pioneers. We have to kick the door down. It's going to be difficult for us. What I'm saying to you guys has not been done before. Most people do not attack it this way. So when you do it this way, you guys are going to have to fight the hardest, but you're fighting this for your children and your grandchildren. That's what I believe. Okay.
Hopefully that answered his question. Is there any other questions? We got room for one more.
One more, and then that'll be it, guys.
I got a question.
Anyone on your side, Kelby? Yes.
Yeah, hold on. Go ahead, 701.
Hey, Rodney, Tom Benson, and Lim. Just wanted to just a quick shout out. Thank you, and we really appreciate what you're doing. God bless. I yield.
Hey, Tom, it's great to hear from you, brother. So you take care, man.
Excellent. If there's no more questions, I think we're going to call it here then. All right. Rodney, blessings to you, and we pray that you have a wall of fire protection around you. We're going to do this again, you guys. We're talking about putting these seminars together, just getting it, the details hashed out about it. So that'll be coming. And Rodney, as things come up, if there's more that you want to talk about, more that you want to share, more that you want to send over, please do, and we will get it dispersed, whatever it is you need. We're here. So thank you, everyone. Thank you to his advocate and Kelby for joining us tonight. We love you guys over there, and thank you to all of our people that came out tonight. Spread the word, call in, listen to the replay, and write this stuff down because we got some really good information tonight. So with that, we're going to sign off. Good night, everyone, and thank you for coming out. We'll see you on Thursday, 42action.org. Good night, everyone.
Thanks, guys. Good night.
Your conference recording has stopped.